Eku Iluna, please rise. O hea oko e ko ka aha. Ina he kule ana I mua o kia aha ho'o kolo kolo ki e hano hano o ka moku aina o Hawaii. E naue mai, e maliu mai I lohe ia ka leo. Hear ye, hear ye, hear ye. All persons having any business before this Honorable Supreme Court of the State of Hawaii, draw nigh, give your attention, and you shall be heard. E noho ilalo, please be seated.
Please call the case.
Case number SCWC-19-0000668, ROWENA AKANA, Petitioner Appellant versus Hawaii State Ethics Commission, State of Hawaii, Respondent Appellee. Arguing for the Petitioner Appellant ROWENA AKANA, James Bickerton, also appearing, Jeffrey Tracy. Arguing for the Respondent Appellee, Hawaii State Ethics Commission, State of Hawaii, UN Rayner. Argument on the merits.
All right, good afternoon, aloha everyone. Our proceeding today is being broadcast live on our YouTube channel as well as on Olelo. Counsel, you ready to proceed? Mr. Rayner, you as well? Okay, 30 minutes for each side. Mr. Bickerton, you've 20 minutes. We'll give you a warning. It says you reserved 10 minutes for rebuttal. And Mr. Rayner will give you a warning with 5 minutes to go. Please proceed.
May it please the court, Honorable Chief Justice and Justices. First of all, I want to apologize if I seem out of breath and flustered. I would have been here half an hour early, which would be a record for me. Got downtown and realized I had left my shoes at home, had to tie my coat. So I blame a wardrobe malfunction. Nonetheless, we are prepared to proceed, and we're very grateful that this court has granted certiorari in this case to consider an issue that really is of great public import. The question of how trustees can spend the money that is part of the trust money that they supervise and control has been before this court quite a few times in different guises and contexts. I do want to make clear as the very threshold point that the money that we're talking about that Ms. AKANA is charged with having misspent is trust money. It's 10-3 money, not 10-13. So OHA is funded in two ways. One is through 20% of the ceded land's revenue, and the other is by appropriations by the legislature, which are more typically the types of funds that are within the purview of bodies like the State Ethics Commission. But the ceded lands money is completely off limits to the state. It's part of OHA's money, and they are charged not just with spending it, but spending it as fiduciaries. And I'll talk in a moment about one of the important cases that has discussed that. But when you're spending money as a fiduciary, it has to be quite different from, say, Joe Smith at the Department of Transportation spending department funds on, a luau or something. Very different indeed. And when we come to this particular case, we look at what the funds were being spent for. The defense was, it is ROWENA AKANA's decision as a trustee that these were properly spent in furtherance of her fiduciary duties. And OHA has set up its own regime, just as in the Boyd case, there was a regime in effect at the time for charter schools. And it's set up its own regime. And the way they take account so that they're different from Joe Smith at the Department of Transportation is they hand a block of money at the beginning of the year to each trustee. They each get the same amount. I think at the time it was $22,000. And they are free to spend it however they want. But at the end of the year, they have to itemize it and say, I spent it on this, and this. And someone at OHA goes through it and decides if those were really trust purposes or not. If they conclude that it wasn't, it's disallowed, and the money has to be returned from that fund. The trustee has to replace it with their own personal funds. So the no money is spent in this system that isn't A, spent by a trustee from a discrete existing fund, and B, reviewed by OHA. Now, factually what happened is that a faction within OHA decided that they didn't like this particular trustee. And one of the things that Your Honors should be well aware of is the misuse to which commissions can be put. These charges are brought against Ms. AKANA just a few weeks before the election, were heavily publicized, and she lost that election. The first time this court ever looked at the Ethics Commission was in 1972 in a case called Doe versus Ethics Commission, which back in those days, it was so new and scary that the plaintiff had to be a doe. And the court ruled at that time that the Ethics Commission had crossed the line in prosecuting someone after they had left office, because the only power the commission had at the time was to issue opinions, and the court said it doesn't help anyone if the person's not in office anymore. The legislature later gave the board the power, the commission the power to fine people. And so that's why, and also to make that fine go to former elected officials as well. So that's what gives them the sort of the avenue to come in this case.
Mr. Bickerton, my understanding of your argument is that the Ethics Commission under our Constitution lacks jurisdiction to enforce the ethics code against the trustees. Is that a fair statement?
That is, Your Honor, and let me just put that in the context of where we are. We're here on a writ, and we did not frame the issue that way. We did say in the lower, in the commission, in the lower court, and in the ICA, we said that the Ethics Commission cannot, as in Boyd, cannot enforce their ethics code when there is a conflicting standard set by law to which the person must adhere. That is very similar, but it isn't the same as the one that we pointed out in the writ. And I apologize to the court that this wasn't something that we picked up. It ties in a little bit to one of the charges. Ms. AKANA was also prosecuted because there was a lawsuit that she brought under the Sunshine Laws to try to gain access to information that was being concealed from her beneficiaries. She did it pro se at first, or with Mr. Seitz, but ran out of funds, and she asked us to help her. And we couldn't afford to do it pro bono entirely, so Princess Kawana Nakoa helped pay for that. But it was absolutely in furtherance of her fiduciary duty as an official act to try to secure documents from the board. It wasn't some personal advantage she was gaining. That was another thing that she was being pursued for. So because of the limited availability, I mean, we could have gone into every issue. There's so many issues, and we didn't get to this one, we didn't see it, and I apologize to the court, but we've seen it now, and because it's jurisdictional, here we are. And it is very clear that if OHA is a separate political subdivision, that's the if before you, and you have to decide that. But if they are, the State Ethics Commission has no right to do anything with them. They have to have their own ethics commission, just like a county does.
You know, when you talk about political subdivision, we're talking about Article 8, Section 2 of our Constitution, and that's really the power of, well, political subdivisions to adopt charters, to frame their government. Yes. You know, typically, I think it seems to extend to counties, and counties obviously have features of tax powers, like most political subdivisions, tax powers, maybe eminent domain, police powers, things of that nature. And I'm just wondering how your Article 12, Section 5, the OHA, the statute that created OHA, how that means or suggests that OHA is indeed an Article 8, Section 2 political subdivision.
First of all, there are 2 points to that, which is Article 8 doesn't say that the only way a subdivision can be created is by the legislature. And I think it obviously makes sense that if the CONCON, let's say tomorrow there was a CONCON and they decided to create a new subdivision and put it in the Constitution, and they called it that instead of calling it Office of Hawaiian Affairs, they called it Hawaiian Political Subdivision. They could do that. So the label that you stick on the duck, if it's still quacking, it's still a duck, whether you put some other label. The question is, looking at Article 8, does it say the only political subdivisions that the legislature may create are counties? And it doesn't say that.
So if it doesn't say that it's quacking like a duck in the statute, your suggestion is that it does quack like a duck.
Well, I think that this particular body quacks like a duck because it has all of these elements that go with the natural and ordinary meaning of the phrase political subdivision, but to also address...
What about the legislative aspect to it?
Well, OHA was authorized by the CONCON, but it was actually enacted by the legislature. The legislature is the one that passed Chapter 10. Two steps had to be taken for OHA to exist and operate. One was the CONCON had to enable it in the general sense, but it specifically contemplates that the enabling legislation will come from our legislature, which they then did in Chapter 10, giving it those
Speaking
powers.
of the CONCON and the, I guess the 1978 legislature, 1979 adoption of the constitutional amendment, is there anything in that ledge history, is there anything in Chapter 84 that suggests that OHA is exempt from the state ethics code?
Well, there's certainly some by implication, because when they talk about expenditure of state funds in Chapter 84, and I'd have to go back and look and see the exact phraseology that they use, but if someone is spending funds that the CONCON and statute have, and even the federal government have said, those aren't the state funds, those are a public trust held by these 5 trustees, or is it 5 or not 9 trustees, to spend for the benefit of Hawaiians and Native Hawaiians, then that's not state money. And that's the implication that you could draw from that statute. I mean, it does boil down to whether the court, I have this thing I say to my associates, I'm not often sure or always sure what the right answer is, but I can recognize the wrong answer when it's given to me. And in this case, I'm here to tell you, I can't tell you, you are the deciders of whether OHA is a political subdivision. It's a very deep question, and it has a lot of implications, and you could go either way on it, and no one could say, that's wrong.
And I think the Attorney General would say that, no, OHA is just a state agency. Your position, I mean, you might be on polar opposites here, is it's not really a state agency, it's something more. And I mean, is that where you're going?
Yeah, I have a leg up on them on that one. And it came to me actually today, as usually the best ideas come right before the argument. I was rereading all of the OHA cases again in the last 24 hours, and I saw one that caught my eye. It said it was OHA versus state. Now, that conjures up a few thoughts right away, doesn't it? I mean, you wouldn't, if you saw Edens versus Edens, it better be Todd and someone different than Todd on the other side.
And hopefully not my wife.
Exactly. But you can't sue yourself. That's fundamental. And so that case came up to this court, and I think it was volume 110 of Hawaii. I'm not sure of the page reference. I have it written down in my briefcase if anyone needs it. Should be easy to find. And what OHA was doing was saying, state, we're suing you because these same trust funds aren't being properly spent. And remember, Chapter 673 was adopted that created these rights for various groups and people to pursue trust claims for, among other things, ceded lands money. So OHA sued the state. And there wasn't Justice Moon and the justices in charge at that time. They didn't go like, wait. You can't sue yourself. You're the state. How can you sue the state? And in fact, OHA was trying to argue that it was the state because it had a statute of limitations problem. And it said, well, we get 657-1.5 because we're the state. And so we're protected. We can still go forward. And the state says, nuh-uh, you are an independent political entity, and you don't get statute of limitations that the state gets. And the court said, we agree with the state. So the state will have to overcome that in trying to suggest that, well, they're just another, they're just like DLNR or BLNR or these other agencies or the State Ethics Commission itself.
Well, but of course, no other state agencies, I think, are elected, are they?
That's another indicia of the separate political subdivision, like counties who have council members elected, yes. I mean, we list all the indicia and what the natural meaning of the term political subdivision is. But again, I can only push that argument as far as it'll go here on this side of the bench, and the rest is just up to you folks. And I think it's an important question that needs to be resolved.
Mr. Bickerton, what about the board and its, I think, policy manual adopting the code? I guess,
Well,
its own.
there are 2 points that we make about that. First of all, I didn't hear about the BLNR or the DLNR or any other state agency adopting the code. They don't have to. It's baked in. Why are they adopting this code? I don't know. But the second question is, why is it necessary for them to adopt a code if they're under the other code? They're going to be administered and it's all going to be enforced. And the third question is, if this board says we're going to, remember how they adopted it? They just put a "you shall comply" in their executive policy manual. It's a policy manual. Obviously, you can, in some instances where it doesn't conflict with your fiduciary duty, do your best not to, spend the money and give it to your friend to go party with, right? That would obviously not be consistent with the fiduciary duty either. The real problem comes is when the fiduciary duty dictates that you do something and it's in your discretion and you can only be challenged for an unreasonable decision, to then take the template that the commission uses and place it against that you're exactly in the Boyd situation. And that's the problem. So the two problems are, one is they didn't have to adopt the code if they were under it. And two, if they did, it doesn't mean it's law. It's just an executive policy manual. And finally, their own interpretation or understanding of what the rules are. It's not finally, I have one more point. Their own interpretation and understanding doesn't control what the law is. And the last point that I would make is that the expenditure of funds by a trustee is ultimately reviewable by the 9 trustees. You can have policies and procedures, and you can even have this bean counters who look every year at and disallow or allow the expenditures. If they're not happy, their remedy is to get the executive director to get a board vote like, hey, was Miss AKANA supposed to spend this money? Not to go whining to the State Ethics Commission and say, well, we couldn't really shut ROWENA down because, she was mean to us. I mean, that's in the record. That's what happened here. They claim that, well, yeah, she never got dinged for this stuff by the by the board and by OHA. OHA allowed all these expenditures, but that was because she bullied them.
Counsel, can I ask you, the one case you referred to, was that cited in the briefings?
I don't think it was.
Could we get that cite later?
It may have. I can get it right now. It's 110-338, HAWAI'I State. It may have been cited in the brief, but I didn't look to see if we had.
Thank you. What I want to ask you, was there anything in the ethics code that imposed any requirements on Trustee AKANA that conflicted with her fiduciary duties?
Well, yes, to the extent that she has freedom. See, a fiduciary duty is very broad. You have discretion. You can spend if you want or if you don't want. The only thing that governs you is, can you reasonably say that this is going to enhance or further the purpose of the trust, which in this case is the betterment of Hawaiians and Native Hawaiians.
So you're saying she had broader discretion?
Not just
under
that.
the fiduciary duties?
Not just that. She had a duty. So there's 2 parts to it. You have wide discretion because you're a trustee and you have to think in a very big picture way. And I'll mention that Kealoha versus Machado and the cases that preceded that, the big issue was a lot of people were criticizing. They were saying, you're spending this money for regular non-native Hawaiians, regular Hawaiians. Now, I call them regular, but there were Hawaiians and there's Native Hawaiians. Native Hawaiians was defined by blood quantum, 50% or more. And Hawaiians were anyone with any amount of Hawaiian blood. And so the trust has some language in about it. It has to be for the betterment of Native Hawaiians. Elsewhere in the statute, it says you can spend for both. These Native Hawaiians sued saying, hey, you can't spend money because you're benefiting Hawaiians and Native Hawaiians. And the court said, you know what? As long as it's benefiting the Native Hawaiians, they can do it however they want. It can benefit other people too. But the point is they got to be bettering Native Hawaiians. If it's not doing that, they're not doing their duty, and they have wide discretion as long as they're doing that. But then they have a duty on top. The fiduciary duties of loyalty, the fiduciary duties to further the purpose of the trust. These are duties. So when you have a duty pointing you this way, and another duty from the State Ethics Commission pointing you the other way, which says don't spend that money on any of those things, even if you think they better Hawaiians, because they may benefit sectors of the public.
Was there any finding that any of the alleged violations constituted a breach of her fiduciary duties?
Absolutely not. From the first day, they all pretended it was apples and oranges, and that's the problem with the ICA opinion. I have a real issue, and I don't get much chance to talk to you folks, and it's something that bothers me a lot. I was on the commission on appellate issues for the State Bar 20 years ago. This was briefed in 2019. They went 5 years before issuing this opinion, and they come up with 2 paragraphs on these 2 main issues that we're talking about today. And they're wrong. They say, oh, fiduciary duty is different from ethics rules. Apples and oranges. You know what? Yeah, but if you're going to try to stick the apple into the orange bag, there is a conflict between the apples and the oranges. So the judges who wrote the opinion in the ICA just skated right past that. The lower court, the commission, no one ever would accept our contention that a fiduciary duty conflicts with having this regulatory scheme. And that was the point in Boyd. I see my light has come on. I'm not sure how long it's been on.
You can keep going. Just went on, but
Okay, thank you.
keep going if you'd like.
But in Boyd, that was it. There was a comprehensive regulatory scheme for Mr. Boyd in 302B or whatever the charter school statute was at the time. I think it's since changed. And they said, well, but he's governed by that and he's in compliance with that. So if he's complying with that and yet it's violating something else, that's an irreconcilable conflict. And the ICA
There's a statute there that explicitly sort of carved out the charter schools.
correct. Although it did not mention Chapter 84, it didn't carve it out by name. It just said, we're going to regulate all your spending of money and all your ethics. Your ethics are going to be under this chapter. And the court said that's more comprehensive and direct, and it supersedes 84. Here we have a problem with fiduciary duty is by definition, it can't be jots and tittles and exact P's and Q's. It's giving them wide power. They are trustees of a public trust. They have wide-ranging, they're elected political figures who have to make policy and philosophical decisions about how to further the interests of Native Hawaiians and Hawaiians. And to do that, you can't have the State Ethics Commission looking over your shoulder saying, oh, wait a minute, that's going to benefit this sector more. I mean, the classic example is the trustee feels that to better serve the people of her constituents who can sue her under 10-16 if she breaches her fiduciary duty. And the better way to serve them is, you know what, I'm going to bring Manapua for my staff today because they've been looking a little down and I've been working them real hard. Now, that's within the power of a trustee. No one's ever going to question a trustee for spending their trustee allowance on helping their staff improve morale. But it does violate the ethics code because you're using public money to benefit one individual over everyone else. That's what this case was about.
What about the statutes that, for example, impose ethics training on OHA trustees? So it seems the legislature understood or implied, or I guess assumed that they were covered. What's your take on that? The requirement that they undergo annual training or the requirements regarding filing financial disclosures?
I want to be very clear. This case is not about, trustees get to be unethical. It's not about that. If they need training, they should have it. If the state wants to offer it or even mandate it, I believe they may be able to do
training
that.
in the ethics code.
To understand it, to know when it might apply to them, when it wouldn't conflict. I don't see a conflict between that and saying, on the other hand, we're going to prosecute you and fine you if you violate it. That's what we're here about. Not about whether they should have some familiarity with it. There's some great principles in the ethics code. What they really need is their own ethics code, which is what the Constitution says. If they're a political subdivision, they need their own ethics code and their own ethics body. That's what the Constitution says. If they're separate.
On that point, Mr.
Yeah.
Bickerton, so I think your argument, clearly is, hey, was a political subdivision a big question? But if that is true, as you have just pointed out, it should have its own separate ethics commission.
It should,
And that has
they haven't
never-
done it.
There's
But
nothing
that
there.
doesn't allow this, the Constitution doesn't allow this ethics commission to go and rush in and fill that vacuum. We've been waiting many years for the state to designate lands of agricultural significance. They're mandated to do that, but they never did.
I think the question simply is how people have actually understood the application of the ethics code or not, and what is a reasonable reading of it, given the constitutional provisions, both for OHA and under the Code of Ethics, right? I mean, we have competing constitutional provisions here.
I think they can be harmonized because the Constitutional Commission that sets up the Ethics Commission specifically says it only applies to the state and the CONCON, and each political subdivision will have its own. So that can be harmonized completely if OHA is its own subdivision. It just had to do it, and they never realized it. That's a different question.
So address this for me, if you would, please. I know we're watching your time, but the Code of Ethics was adopted prior to OHA.
Yes.
Code of Ethics was promulgated in our Constitution in
Late
1968.
60s, I think,
Right,
we
1968.
developed.
OHA created by the 78 CONCON. In the
I
68,
think the ethics was, we had an ethics code and an ethics commission in that first case I mentioned was 1972.
yeah, I'm talking about in terms of the promulgation
Yeah.
of the constitutional provisions, right? And in the promulgation of the Code of Ethics in 68, they speak to the political subdivision, and the legislative history there speaks to counties.
Right.
Is there something separate in the constitutional history going forward that undermines that, I guess, statements that they're talking about the counties when they're talking about political subdivisions?
Well, you're dragging me into a debate that I don't like because I see the US Supreme Court doing it, which is, are we textualists? Are we originalists? If you read the plain language of the Constitution, it uses the term political subdivision. Should we delve into it? Clearly, it's meant to include counties. Do we delve into behind that, if it's ambiguous, which if you think it is, you should, and say, did the CONCON exclusively mean the counties, or was it was it envisioning that there might later be other types, or even that year there might be created another type of subdivision? That I am not a master enough of the the legislative history to know.
Part of what we are, I think, required to do is at least look at what the drafters intended. It's not the whole ball game, but
I agree.
yeah,
I agree. We only had 12 pages on the writ, and I think that you're right. I mean, you have to look at that. And we have not, I don't think we've done a thorough job ourselves of delving into the CONCON history, because this was not an issue that we saw until after the ICA ruled, and we were scratching our heads over how short of a shrift they had given to the main arguments that we did make, which are perfectly good. Unfortunately, the argument in the writ is a constitutional one, jurisdictional,
Right.
and I think your burden, unfortunately, is to address that first before reaching the others. But you're free to say no. We're going to skip that. We don't want to grapple with Constitution. We're just going to say it's a conflict, just as in Boyd and in Kealoha versus Machado. We really got into what it means to have a fiduciary duty and why you can't sue these trustees when you disagree with how they've spent the money. As long as they meet these standards, you have to shut up. And that ruling in Kealoha versus Machado applies to the commission too. Thank you.
Yeah, thank you, Mr. Bickerton. We'll save the rest of your time for rebuttal. Mr. Rayner.
Good afternoon, Chief Justice Rechtenwald and Associate Justices of the Hawaii Supreme Court. My name is ROWENA, Deputy Solicitor General, arguing on behalf of the Hawaii State Ethics Commission. Your Honors, I'd like, if I have time this afternoon, to try to address three separate points. The first is that the Office of Hawaiian Affairs is not and was never intended to be a political subdivision. Second, that the application of the Ethics Code generally and the Commission's decision here specifically does not conflict with or otherwise infringe upon Ms. AKANA's ability to perform her duties as a fiduciary. And finally, that the application of the gifts law also does not conflict with Ms. AKANA's duties as an OHA trustee. So as to the first of those, interpreting OHA as a political subdivision would be contrary to the intent behind Article 12. It would be contrary to the intent behind HRS Chapter 10. It would ignore the long history of OHA itself believing itself as a state agency and never raising the fact that it believed to be a political subdivision. And it would also potentially have significant implications.
If you could just step back just a tad, or we could just bring the volume down just a little bit. Thanks, yeah.
Okay. It would also have potentially significant implications, not only to OHA's governing statute, but also to the governing statutes of other state agencies, which, like OHA, were granted a certain amount of independence from the executive branch, because Article 8 of the Constitution, which governs political subdivisions, specifies that political subdivisions are subject only to general laws, whereas Chapter 10 is specific only, it applies only to OHA. So the Office of Hawaiian Affairs was established pursuant to Article 12, Section 5, which was drafted during the 1978 Constitutional Convention. There is nothing on the face of Article 12, Section 5 that indicates that OHA was intended to be a political subdivision. And it's important to note that in 1978, when Article 12 was drafted, Article 8, which governs political subdivisions, was already in existence at that time. And given that OHA does not conform to the typical traditional understanding of what a political subdivision is, one would expect there to be something either on the face of Article 12 or in the history of the standing committee reports or the delegates' comments to indicate that OHA was intended to be a political subdivision. But there is nothing of the sort. In fact, the only thing there is that in the standing committee reports is an explicit indication that OHA was intended to be a state agency, a unique state agency nevertheless, but a state agency nevertheless.
Although independent from the executive branch, so.
I'm sorry?
Although independent from the executive branch, that same passage that you referred to.
Certainly, so there is definitely an intent to make OHA, to give it a level of independence from the executive branch. But I think that does have to be looked at in context as well, because there are two, when the delegates were creating Article 12 and talking about the intent to make OHA independent, there were two concerns that were really at issue. The first was that there was a concern to make OHA financially independent to avoid commingling of funds from the land trust with the state's general fund. And secondly, there was a desire to ensure that OHA's beneficiaries would have a democratic process by which to elect the OHA leaders. And what's clear from the history of Article 12 is that the delegates believed that they could achieve those those goals of making OHA independent by making it a state agency, a unique state agency modeled after the model of the University of Hawaii.
But there are significant differences between OHA and the University of Hawaii, correct?
There are certainly differences.
How do you define the attributes of a political subdivision?
So a political subdivision, I mean, as the name suggests, it has to be just that. It's a subdivision. A subdivision, which is a government entity that is established to exercise governmental functions over an area of the state that is within the state, but smaller than the whole of the state, like a county.
What legal authority does OHA have over the lands that were to be or have been transferred to it?
Well, it does have authority over those, and it can hold title to those lands. But what I don't think can be...
Does OHA get to decide what to do with those lands and how those lands are going to be used?
It has that jurisdiction, yes. But what I don't think can be disputed is that OHA, the issues that OHA governs and the jurisdiction that OHA has is a matter of statewide concern. The betterment of Native Hawaiians is not a local concern. So the sort of the hallmark of a political subdivision, it is created to exercise jurisdiction over a subdivision of the state, a small part of the state, and to exercise local government functions.
Okay, I understand. But in terms of after Rice versus Cayetano, the Constitution still says that OHA trustees have to be Hawaiian, right?
Right.
And is that continuing?
Well, pursuant to Rice versus Cayetano, no.
I thought it only addressed the voting issue. But it says the trustees have to be Hawaiian. Has that been struck down too?
I'm sorry?
Have we had a non-Hawaiian trustee?
I don't believe so. I'm actually not sure.
Okay.
But I think in addition to the history of Article 12...
In terms of the intent of the people, you keep talking about, when we construe constitutional provisions, we're supposed to be going with what were the intent of the people that ratified that constitutional provision.
Correct.
For many years, non-Hawaiians did not vote in OHA elections, right? And I just think, I don't know when it started, but I know that historically, we have the three branches of government on all official functions. We have the three branches of government, and we have the head of OHA sitting there along with the three branches of government. We don't have the president of the University of Hawaii sitting on the stage. So it seems to me that there are some attributes in terms of what the people intended as to what the status of OHA was supposed to be. It seems to me, it's a little bit different from the University of Hawaii.
I don't dispute that there are differences. I mean, and one of the differences...
The question is, does it rise to the level of a political subdivision? And in terms of that, what is the definition of a political subdivision? What are the attributes of a political subdivision?
Right.
The power to have its own land, to control its own revenue, etc.
Well, no, I think
elect its own officials.
The hallmarks, like I said, of a political subdivision. First, that it has to be a geographical subdivision of the state. That it has to exercise local government functions, and it's often traditionally been recognized that there is one of the traditional sovereign powers, such as the police power, the zoning power, power of taxation, which we don't believe OHA has any of those specific sovereign powers. And the other thing I would say that I think is a very powerful indication of what the intent was behind Article 12 was the subsequent legislative history of the creation of OHA. So in 1979, when the legislature set about actually creating OHA pursuant to Article 12, for one thing, there were delegates that were on the 1978 Constitution that were already in the legislature at that point during the process of the creation of the adoption of HRS Chapter 10. There are also some of the leaders on the Committee of Hawaiian Affairs in 1978 CONCON that testified during the legislature's adoption of Chapter 10. Never in any of that period when the legislature was adopting Chapter 10 in 1979 did anyone raise the issue of OHA being a political subdivision. And it would have been an objection that would have been...
Well, that doesn't mean it's not. I mean, they have their own separate constitutional article. They have their own comprehensive statutory scheme under Chapter 10 that gives them all kinds of powers, including under 10.4.5. It says, notwithstanding any law to the contrary, the power to make appropriate disbursements. I mean, doesn't that cover Trustee AKANA?
So it does, but the one point I would make about that is that the very fact that Chapter 10 adopts all those kind of powers and specifies the powers that OHA has and applies it only to OHA is itself an indication that OHA was not intended to be a political subdivision.
But it says notwithstanding any law to the contrary. Wouldn't that exclude the ethics code?
It couldn't exclude Article 8 of the Constitution. Article 8 of the Constitution requires...
What about the ethics code? Would that be notwithstanding any law to the contrary?
No, because it's not to the contrary. But the point I would make about Article 8 is that it requires that laws applicable to political subdivision be general laws of general applicability to the political subdivisions. But Chapter 10 applies only to OHA, specifically to OHA. It grants powers, very specific to OHA. And that is...
She had different fiduciary duties that she owed to the OHA beneficiaries, Native Hawaiians and Hawaiians. And she's saying that I made those expenditures in good faith for those purposes. Now, it may have conflicted with the ethics code, but she felt she did the right thing.
So certainly there may be some overlap between the fiduciary duty and the ethics code. And I think
Which one is she supposed to follow?
She's supposed to follow both, yes. There's no reason that the ethics code cannot apply alongside the fiduciary duty. And it's actually a fundamental tenet of trust law.
But their internal process didn't find any wrongdoing on her part. If there was a disallowance, it was reimbursed. They had a mechanism there. I believe there was testimony from Ms. Iona that at the end of the year, her allowance always reconciled. There was nothing that went wrong internally.
In fact, the commission found that every single expenditure that Ms. AKANA made from her trustee fund violated OHA's policies. Every single expenditure, the commission found. Those findings are not challenged. So it's very difficult for me to see that Ms. AKANA can argue that she was spending her trustee allowance in furtherance of her fiduciary duties when it was not consistent with OHA policies. Now, the entity that is in the best position to determine how to further OHA's mission is OHA. I mean, the commission doesn't dispute that. And when OHA makes policy determinations, it establishes a policy which is adopted by the Board of Trustees itself. When they make that policy, they make those policies that specify how the allowance can be spent, the commission will not second guess those policy determinations. Now, certainly the issue the commission has with Ms. AKANA's conflict argument here is that she essentially asserts that just the existence of a fiduciary duty alone is sufficient to mean that there is no jurisdiction whatsoever for the ethics code in total. And there's no jurisdiction for the commission to enforce the ethics code against OHA trustees. But if Ms. AKANA was able to establish a specific duty, a specific statutory duty, or something she was required to do, if there's a legally imposed duty that required her to make these expenditures, then she would have a defense to the specific charge in the Ethics Commission that is being charged against her. The problem is that she has never done that in this case. And like I said, the evidence of that is that for every single expenditure she made, the commission found that it also violated OHA policy. And like I said, the best entity to determine the best way to further OHA's mission.
So you're saying the Ethics Commission made the judgment that these policies would have violated OHA's policy, even though what judgment did OHA's internal review process come up with?
So OHA's internal review process was not by the Board of Trustees, it was by OHA's staff. Some of the expenditures they approved, some of them they did not approve. But the evidence in the record, the testimony from OHA's staff, pretty clearly indicates that that is not an indication of whether it is permissible under OHA's policies. Because of the way the allowance works, where the OHA's essentially, the trustees at the beginning of the year get a check cut to them and then spend the funds out of that account and then have to reconcile them later. The testimony in the contested case hearing was that OHA understands, and OHA staff understands, that they're going to miss some of these expenditures that are not really consistent with policy.
They seem to be making excuses about intimidation and everything else when they had a job to do internally.
Well, I mean, I think that was just evidence that it was very difficult to ensure that each of the trustees was, in particular Ms. AKANA, was actually spending her allowance in conformance with the policy. But what is clear about the testimony was that the internal review process by the staff is never meant to be an indication or an official determination of whether it applies with OHA.
So in
Policy.
this case, it was the Ethics Commission that determined that there were Chapter 84 violations that or violations of OHA's own policies, right? In terms of
Yeah, so
okay.
when it looked at each of the violations,
So how far do other state laws go to applying to OHA? So can the Hawaii Civil Rights Commission then, if somebody filed a complaint saying that OHA trustees are improperly expending money only for for Hawaiians,
well,
Native Hawaiians, would then the Hawaii Civil Rights Commission have jurisdiction to say this is a violation of our discrimination laws?
well, I don't know enough about the Hawaii Civil Rights Commission's jurisdictional background to really be able to answer that question. I mean, that's never been briefed in this case, and it's not research I have done. But what I will say in this case is
the issue that Ms. AKANA's counsel is raising is whatever we decide in this case is going to have ramifications well beyond the specific issues in this case. And therefore, I'm trying to ascertain, you know, what you're asking this court to hold. But I do have a question. Under 10-1, the Declaration of Purpose of OHA, it says, it shall be the duty and responsibility of all state departments and instrumentalities of state government providing services and programs which affect Native Hawaiians and Hawaiians to actively work toward the goals of this chapter and to cooperate with and assist wherever possible the Office of Hawaiian Affairs. It just seems to me that that kind of indicates, and 10-1 subsection A talks about how, you know, the people of the state of Hawaii reaffirm their solemn trust, obligation, responsibility to Native Hawaiians, and furthermore declared in the state constitution that there be an Office of Hawaiian Affairs to address the needs of the Aboriginal class of people of Hawaii. And I know it's not clear, but it does seem that this is a little bit different from the University of Hawaii or the Board of Land and Natural Resources. There is the sense that OHA is somewhat independent and other state agencies are supposed to assist. So does assist mean the Ethics Commission jumping in and say, hey, OHA trustee, you are violating OHA's policies?
so I think I can try and answer both questions, so the kind of your earlier question and that one as well. In that, when you're looking at the jurisdiction of the Ethics Commission, and particularly as it applies to OHA, we're looking not only at OHA's governing constitutional provisions, Article 12 and Chapter 10, we also have to look at the Ethics Commission's governing law, which is Article 4. That's Constitution as well. Article 14 of the Constitution sort of requires that the, you know, I have it right here, so, there requires to be a code of ethics which shall apply to appointed and elected officers and employees of the state or of the political subdivision, including members of the boards, commissions, and other bodies. Now, given that both that article, Article 14, and Article 12 were adopted at the same time, and HRS Chapter 84 and HRS Chapter 10 were also sort of crafted at the same time, one would think that there would be some indication if the legislature...
Chapter 84 came into effect in 1972.
There was amendments made in 1979. That initially was created before that, right? But the constitutional provisions were both drafted similarly. But the point is that there would be something, given that the Article 14 is broad enough to include OHA trustees, and that there is an intent in Chapter 84, you know, Office of Hawaiian Affairs trustees are specifically mentioned in Chapter 84. One would think that there would be somewhere mentioned, if there's an intent to exclude the Office of Hawaiian Affairs trustees or Office of Hawaiian Affairs staff, that would be indicated somewhere. But there really isn't anywhere that is indicated that it was not intended to include them. And in fact, the contrary is true, is that the only intent we have is that there's an indication that they were intended to be
Is OHA
included.
excluded specifically from our anti-discrimination laws?
I
Chapter 368, is it? Is OHA specifically excluded?
don't believe so, but I can't answer that definitively.
Then how could it be enforced against OHA then under your?
Well, no, because it would be
argument?
contrary to OHA's constitutional governing provision, which is Article 12. Obviously, a state statute cannot trump what the Constitution says. But here we have a constitutional provision that applies to the ethics code that requires state employees, state officers, elected and nominated officers to be covered by the ethics code. And so I think that would be a slightly different situation.
May I ask you, we're talking about the University of Hawaii as something that's a close model, and under the definitions under 84, when it defines state agency, it specifically identifies the University of Hawaii, but it doesn't for OHA.
Sorry, which provision was that specifically identifies?
Under the definitions, under Chapter 84, it defines a state agency, and it specifically identifies UH, but it doesn't mention OHA, if I remember correctly.
I don't recall where it mentions the University of Hawaii, but the Office of Hawaiian Affairs
It does mention the University of Hawaii.
Okay, well, the Office of Hawaiian Affairs, in fact, Office of Hawaiian Affairs trustees specifically are included in Chapter 84. They're required to participate in mandatory ethics trainings. So
I don't dispute that. I'm just talking about the definition of a state agency, because that's part of the critical question here, right? Whether it's a state agency or a political subdivision or something in between. But under the definitions under 84, I think it's 84.3, state agency, it doesn't identify OHA.
I'm sorry, I'll just have to look at that provision. You're right. So it does include the University of Hawaii. So it says it includes the state, the legislature, its committees, all executive departments, boards, commissions, committees, bureaus, offices, the University of Hawaii, and all independent commissions and other establishments of the state government, but excluding the courts. I think that last part is significant because it demonstrates there that the legislature, when it was crafting Chapter 84, knew how to explicitly exclude an entity or a specific type of state employee, and it excluded judges and justices, but it certainly does not exclude explicitly Office of Hawaiian
So
Affairs.
how is OHA included in this definition of state agency?
I'm sorry?
Which provision of this definition of state agency includes OHA?
It would be included in the boards.
No, it's executive departments, boards, commissions, committees, bureaus.
I mean,
All
okay, so
boards, okay.
just to back up and slightly, the definition of state agency, I don't believe is actually entirely relevant to determining whether a specific state employee or state officer is included within the ethics code, because the ethics code, it has certain limited provisions that apply to agencies, but really the ethics code applies to individuals in the state government. And so the definition of an employee, OHA trustees fall under the definition of employee in the state. So I think what we need to look at is more the definition of the employee rather than a state agency to determine
But
whether.
are you asserting that OHA is a state agency? Is that part
Absolutely,
of the argument?
yes. Yeah, I mean, the delegates in the 1978 CONCON, the Standing Committee on Hawaiian Affairs, explicitly stated it's intended to be a state agency. It used those words. So I don't think it can really dispute that it was intended to be a state agency.
Although the legislature didn't include it in its definition.
No, it didn't exclude it. It didn't include it specifically in its definition. But again, the Ethics Commission is primarily concerned with the conduct of individuals rather than the agencies themselves. And our position is that an Office of Hawaiian Affairs trustee and Office of Hawaiian Affairs staff are included in the definition of state employees.
I'd like to ask you a question that maybe fills in my gap or my understanding about the record. And we're shifting gears a little bit from the political subdivision arguments. Mr. Bickerton says, hey, look, the bean counters do their thing at the end of the year. There's these internal controls historically. And then what happened here was, rather than engage in that seemingly routine process, they went running to the Ethics Commission. Did Ms. AKANA have the opportunity to, after the internal control process play out, pay back what was perhaps suspect?
So she did, and some of the expenditures which were found to be not in violation of OHA's policies were paid back. Some of them were not. So essentially, I think the record demonstrates that was that opportunity there, and certainly some of the expenditures were paid back. But the commission found that it was sort of, at least as far as the ethics violation goes, the violation of the fair treatment law, it was sort of to a degree irrelevant whether they were paid back, because HRS 84-13 makes it a violation of the fair treatment law to attempt to use one's official position to.
But I guess what I'm getting is, a trustee could wait to see maybe something might be up in the air, whether it is legit or not. And I guess what I'm getting at is was there, I guess, a process or a mechanism for her to, the bean counter says, hey, you owe some money here, and, she either paid it back or not. Did she have the opportunity? Let's say the princess's attorney fees issue. Was she given the opportunity to pay that back?
For the gift?
Yes.
The gift store. So, I don't, the record is not very, very clear about what OHA's internal policy is for allowing that. Other than to say that.
What about the other matters that she was found in violation of? Was there the opportunity to, before running to the Ethics Commission, her to engage in the normal year-end process?
Yeah, there was. And, I think what the record demonstrates was that there were multiple instances where Ms. AKANA was sort of informed that she couldn't use the allowance to pay for some of the things she was paying for. And a good example of that was her home cable bill. She was informed by OHA's CEO that she could only claim, I forget the exact amount. It was, I believe, $30, or maybe it was more. But she continually, after that, attempted to claim significantly more than that, $80 a month after month after month, after being informed by the CEO that that wasn't a permissible expense. And so certainly, I think the record demonstrates that there was an opportunity there for her to first of all, stop seeking to use the allowance for matters that were not permissible under OHA's policies, and secondly, to pay those funds back. And in some cases she did, and in some cases she didn't. And I just want to make one final point while I have time in regard to the application of the gifts law. So Ms. AKANA has argued that the application of the gifts law and to her receipt of legal fees for payment of her lawsuit against the OHA board was sort of in conflict with her fiduciary duty. But there's a couple of points I would make about that. The first is that the statutory provisions she does identify that she claims permit her to collect and receive money to use in furtherance of her duties, and which in her arguments essentially exempts her from the gifts law. That is HRS 10-5 subsection 3. But the problem with her argument on that law is that that specifically only, I see my time is up.
You can finish your answer.
Thank you. that law applies only to OHA's board. It gives the board authority to collect and receive money, and it only the authority to do so on behalf of the office, not to individual trustees. And the other point is just that the commission here didn't prohibit Ms. AKANA from receiving funds from beneficiaries. Out of the many payments that were made for her legal fees in this case, the commission only found that 2 of them were actually in violation of the gift code, and those are the 2 that occurred after Ms. Kwana filed her own lawsuit against the OHA board. And in that context, the commission found that it was reasonable to infer that the payments were made for the intent of influencing Ms. AKANA's decision-making. But as to the other payments, the only law that the commission found was violated was the gifts reporting law. And there's certainly nothing in OHA's governing laws or in Chapter 84 that would, or anything that Ms. AKANA has indicated that would conflict with reporting gifts with her fiduciary duty.
I do have I'm sorry.
No, please go ahead.
Did you discuss HRS 10-16, subsection C in your?
I didn't discuss it today, but it is in a briefing.
Okay, all right. So what do you make of the provision that says in the matters of misapplication of funds and resources in breach of fiduciary duty? I see. So that's for breach of fiduciary duty only. Board members shall be subject to suit brought by any beneficiary of the public trust. Okay, so that sounds like it's for breach of fiduciary duty. But subsection D relates to in matters involving other forms of remedies, the office, its officers and employees, and the members of the board shall be subject to suit as provided by any other provision of law and by the common law. Okay.
Yeah, so essentially our position, Ms. AKANA argued that I believe subsection C essentially precluded the Ethics Commission from bringing an enforcement action, but our position is that that's certainly not what this section intends, and subsection D indicates that for other laws other than breach of fiduciary duty, then the trustee would still be subject to a suit or an enforcement action.
So your position is that her perception of what her fiduciary duties required would always be identical to what the ethics code required. In other words, I understand Mr. Bickerton to be saying the trustee may believe that a certain expenditure is justified in furtherance of her fiduciary duties, but it could be a violation of the ethics code, and that's a conflict that the intention was not to place that trustee in.
Yeah, so I think there could be. Okay, so just to back up, I think it's very unlikely because as the record in this case demonstrates, the commission carefully, for each charge and for each violation, it looked carefully at OHA's policy to determine what OHA itself, through the Board of Trustees, was allowing for use of the funds. And like I said earlier, for every single violation of the fair treatment law, it found that Ms. AKANA's expenditures were in violation of OHA policy. And the commission is not going to second guess OHA policy on those kind of policy determinations. And so I think it's extremely unlikely that there would be a situation where those two things didn't.
Why did it do that? Why did it care what OHA's policies were?
Because the entity that is in the best position to determine how to further OHA's mission is OHA. Saying that, however, there may be, it may be possible to think of a hypothetical that where, the OHA trustee believes that something is in furtherance of their duty, and maybe the policy is not clear, the OHA policy is not clear, that could still be a violation of the ethics law can there's no reason that the two cannot coexist. There's state employees can be subject to numerous duties, including the ethics code. Just because the two of them exist in tandem does not mean that one of them can't necessarily apply. So our position is that she would have to comply with both.
So if a trustee, it's $20,000 a year, is that what the amount is?
Defined?
No, the amount of the.
22,000.
Okay.
Yeah.
If the trustee felt that there were 4 or 5 Native Hawaiian families in Lahaina who suffered terribly as a result of the fire and wanted to use their entire trustee allowance to assist them with housing costs. I don't, in that, would that not be a violation of the ethics code?
On those facts, I don't believe so. I mean, there's nothing in the facts you stated that I think would violate it. I mean, it's often very factual dependent. I mean, if one of them was like a close family member, that might change matters. But on that fact pattern, I don't believe so.
Okay.
Thank you. We humbly ask that the court affirm the ICA's decision. Thank you.
Thank you very much. Mr. Bickert,
May I inquire how much time I have? I know council went over
we got 4 minutes.
4 minutes. I get none of those 10 that he had. I can do it.
Yeah, if you need more, I'll give you more time.
I can do it. I'll try. First of all, there's a factual dispute that should probably not have to trouble you too much, but it's my understanding of the record that these all concern past years, fiscal years that were closed. Ms. AKANA had been, effectively, it's called auditing. They audit what you've spent. They make you say yes or no, and they make you pay it back. And that she paid back everything that they disallowed. So that's not what he said. But anyway, let's say there was a couple items that she had not paid back because she felt really strongly that those were her fiduciary duty to spend those, and she disagreed. The executive staff's remedy is to put it up to the board for a vote. If 5 trustees say, you know what, ROWENA, that's not fiduciary. You're not under any obligation to spend that. You're wrong. It's unreasonable. Pay it back. Then I can see regulating them that way. But to after the internal process has been completed, she's been allowed what she's been allowed, which they prosecuted her for stuff that was allowed. And then she's been disallowed stuff, which she paid back, and they prosecuted her for some of that too. But it's closed, it's done. She's all good with OHA at that point. And then they come in afterwards, a few weeks before an election, and say, aha, maybe OHA's okay with it, but we're not, and we are going to second guess OHA. And there's no way you can put another spin on it. That's what the commission is doing. They're second guessing OHA. They're saying, well, we think those all violated OHA policies, but OHA didn't say that, didn't do that, didn't think that, and didn't act that way. So I think that's important. I want to read Article 8 again, because there was some talk by council about counties and how counties fit together. First of all, it says, Article 8 says, the legislature shall create counties and may create other political subdivisions. So by definition in Article 8, political subdivisions is more than just counties. And then when you ask council, how do you define a political subdivision? He tried to give you a definition that seemed pulled straight out of the definition of county, police power and this and that, but it doesn't really have to be that.
Mr. Bickerton, isn't the title of Article 8 local government, though?
It is.
So doesn't that imply something similar to what Mr. Rayner was arguing for?
The law is very clear that the title is not given weight in construing the text of a statute. The title's there as a chapter guide to help you know what topics it's really focusing on, but it doesn't control over the text. There's lots of case law on that. He said, well, we've got, a specific legislative statute here, Chapter 10. Well, yeah, we got Chapter 42 for counties. It's very clear. It gives them one taxing power and one taxing power only, real property. They've been sanctioned when they tried to tax people for other things by this court. Looking at the conflict, he said it's jurisdictional. No, the conflict issue is not a jurisdictional issue. That's a separate issue that we raised in the writ. The conflict issue isn't jurisdictional. We say that you can't judge it fairly. The SEC is not equipped to make the kinds of judgments that you have to make. That's what we're saying. They don't have the correct rules or standards. And let me tell you about Section 84-13, the fair treatment. This is what it says. It says, hold on. No legislator or employee shall use or attempt to use a legislator or employee's official position to secure or grant unwarranted privileges, exemptions, advantages, contracts for oneself or others. That's what fiduciaries do all the time. they get to, the example of the Chief Justice, I couldn't believe it when counsel said, oh yeah, she could go spend the money for those families in Lahaina. I mean, do we have any standards or rules here? What's the difference between that and saying, I'm gonna buy Manapua today for my staff? What's the difference? Because one is tugging more at the heartstrings, where it's obviously so crazy to say that the trustee couldn't do that. They can do both of them. And there's nothing the Ethics Commission can do about that, because this statute doesn't fit. To use your power for privilege exemptions for others is exactly what the trustee does. And it's for a limited segment of the community, which does violate civil rights. If you really want to get serious about it, you could say it. Where's the fairness in saying Native Hawaiians get all this money? But that's what we let them do. That's their trustee duty to do that. And so we can't have the Ethics Commission second guessing it.
Speaking of it, can I ask you about the fees, the attorney
Yes.
fees that were paid? And in 11.5, I think it's subsection 2, what's your take on whether those fees fit into the statute?
I just don't see how they fit, because the whole idea is to gain a personal gift or a personal advantage. If this was her lawsuit against, to get her job back or to do something like that, that's something else. That's personal benefit. This lawsuit, the underlying lawsuit we're talking about, she sued OHA. It says on the complaint, Rowena AKANA in her capacity as trustee versus other trustees, not for damages, make them release and reveal information they were trying to keep secret about the inside deals to buy their home. When they bought that Gentry Pacific building out there was a lot of shenanigans. Rowena wanted to expose it to the public. She brought a lawsuit to enforce the Sunshine Law. They brought Paul Alston, who spent $500,000 of OHA's money fighting her before we got him to give up. She needed to fight back. She used resources from a beneficiary to fight that lawsuit. How does that fit in the ethics code? She did not benefit personally in any way. She was advancing her fiduciary
So
duty.
when the statute reads, the source of the gift or gifts have interests that may be affected by the official action, of the recipient, how does that play into?
Well, as far as I know, and I'd have to check the record, I don't believe that Ms. AKANA ever was involved in any decision or vote or action on the matter that Ms. Kawana Nakoa brought. It was not a money damages case either. It was another beneficiary versus OHA trying to make them comply with the law type of case. And she didn't.
Would there be any action by Ms. AKANA with respect to that suit by the princess? Would there at any time be any type of official action that she would undertake?
It's possible that she could have been asked to vote, but if she ever was, she could have also recused. That's what people do. Say, I can't do that. I'm tied up with this person. I'm doing things with them. They're helping me, so I can't vote.
And if it did come to that where then she did recuse, then would it be your position she did not fit into 11.5?
Oh, yes. But it never
she didn't have that opportunity.
It never reached that point. It never went that far. So one last point I want to make in response to one of the comments of the justices, 84.3, Justice Devons talked about how you define it, and Justice McKenna was actually reading it. The term executive qualifies a string of words that flow after that, including boards, commissions, and offices. And the way we know that is because then they go comma and independent commissions. So there's executive commissions, boards, and offices, and then there's independent commissions. It doesn't say independent boards. In the case that I cited to your honors, OHA versus, this would be my last point, OHA versus Office of Hawaiian Affairs, this is what the state said. I'll quote from the case. The state contends that section 6571.5 does not exempt the plaintiffs from the statute of limitations for this lawsuit because OHA is a, quote, separate entity independent of the executive branch, and OHA brought this suit in its own corporate name under 10-16 rather than as an agency of the state on behalf of the people of the state. We agree with the state. What was OHA doing there? It was trying to do something about those trust funds. And that's what Ms. AKANA was spending. She is a separate political entity, and the SEC has no business regulating her. Perhaps someone should, and perhaps OHA should adopt its own code. I think it's required to, but that hasn't happened yet. So we respectfully ask the court to reverse this case and dismiss it. Thank you.
Thank you to both of our attorneys for your arguments today. The court will take this matter under advisement.
E ku iluna, please rise. Ua ho'oku ia mai nei ke ia aha ho'okolo ki e hano o ka moku aina o Hawaii. This Honorable Supreme Court of the State of Hawaii is now adjourned.